Okay, let's get right into this explainer. Today, we're unpacking the landmark constitutional dispute of Prince versus President Cape Law Society. Now, if you're a law student or a legal scholar, this is an absolutely fascinating academic case study. It is the perfect illustration of what happens when deeply held, fundamental religious beliefs collide head-on with incredibly rigid statutory law. So we're going to explore exactly how the Constitutional Court of South Africa navigated this profound legal tension, looking strictly at the facts, the statutes, and the actual judicial reasoning.
To keep things organized, we're going to structure today's analysis just like a formal case brief. We'll start with the material facts and background, move into the core constitutional issue, examine the conflicting rights and statutes, dive deep into the Section 36 limitation analysis, and wrap up with the final judgment and constitutional remedy.
All right, Section 1, material, facts, and background, specifically the applicant and the conflict. To truly understand the law, we first have to understand the people and the real-world conflict that actually brought this to the courts.
And really, the beating heart of our case study today boils down to this one massive Socratic question. Can a blanket statutory ban violate constitutional religious freedom? Think about it. When a government enforces an absolute, zero-exceptions ban on a substance, what actually happens when that specific substance is considered divine by a group of people? Does the Constitution demand that we make an exception? Well, let's look at the facts.
So, our applicant here is Mr. Gareth Prince. And picture this. He had completely satisfied all of his academic requirements to be admitted as an attorney. He had the degrees, he was totally ready to go. But he hit a massive wall when the Law Society flat out refused to register his articles of clerkship. Why? Well, because he honestly disclosed 2 previous convictions for possessing cannabis. And, even more crucially, he stated a clear upfront intention to continue using it because his use was directly inspired by his sincere, deeply held religious commitment to the Rastafari faith. The Law Society basically took the stance that someone who intends to consistently break the law would bring the legal profession into disrepute.
Tracing the procedural history here is pretty interesting. Prince initially challenged this in the High Court and lost. They found that while his rights were indeed being limited, it was a justifiable limitation. So, he appeals. He goes to the Supreme Court of Appeal, but they also uphold the general ban, basically arguing that a religious exemption would just be impossible to police. By the time Prince finally reached the Constitutional Court, his challenge had broadened significantly. It wasn't just a fight with the Law Society anymore. This was now a direct, full-scale constitutional attack on the Drugs and Drug Trafficking Act and the Medicines Act. Now, it is absolutely crucial to understand the religious context here. For the Rastafari, cannabis is a sacred, strictly regulated sacrament. It is not a recreational drug. The religion has existed for over 70 years with an estimated 12,000 adherents in South Africa alone who use what they call the holy herb to know God and gain divine wisdom. And it's not just smoked in a chalice either. It's burnt as incense, eaten, drunk as a tonic, even used in bathing. In fact, true Rastafari strictly condemn the casual or recreational use of street drugs. For them, this is a deeply spiritual communion with strict protocols.
Moving right along to Section 2, the core constitutional issue. We're looking at the tension of overbreath. Let's isolate the exact legal question that the court had to grapple with.
So, Prince's main argument was that the statutes were constitutionally flawed specifically because they were overbroad. Basically, the government had a perfectly legitimate goal, right? Fighting drug abuse. But the law cast a net that was just way too wide. It ended up catching and criminalizing conduct that really should be protected by the Constitution. Like, for example, simply burning cannabis as incense during a bona fide religious ceremony.
And we need to be super precise about this. The court was not being asked to legalize cannabis for everyone. That wasn't the goal. The state's legitimate interest in fighting the war on drugs was actually never in dispute here. The challenge was highly targeted. The question was simply, could the legislature achieve its anti-drug goals without completely banning safe religious uses by the Rastafari? Were they failing by not providing a religious exemption?
Okay, Section 3, conflicting rights and statutes. This is where we see the real legal tug-of-war play out. We have a massive direct standoff here. On one side, you have the supreme law of the land, Sections 15 and 31 of the Constitution guaranteeing freedom of religion, and Section 10 guaranteeing human dignity. But then on the other side, you have these incredibly strict statutory bans found in the Drugs Act and the Medicines Act. The real-world effect of this clash? Under these statutes, every single Rastafari practicing their religion is automatically treated as a criminal, and the stigma attached to being labeled a criminal is, frankly, a massive invasion of their human dignity.
The tension really pops when you contrast the different uses. The statutes actually did already allow for exemptions. You could legally possess cannabis for medical, analytical, or scientific research purposes under strict regulations. Yet, totally safe religious practices, like burning it in an incense holder on an altar, were completely banned. That contradiction raises a huge red flag about whether the law was actually being minimally restrictive.
All right, on to Section 4, the Section 36 limitation analysis, the proportionality test. For you law students out there, this is the analytical meat of the explainer. This is where constitutional cases are won and lost.
So, applying the Section 36 test, we essentially have to weigh the importance of the state's limitation against the severity of the impact on Prince's constitutional rights. Because remember, just because a constitutional right is infringed, that doesn't automatically mean the law gets struck down. The state always gets a chance to justify its law. The ultimate question is this total ban on Rastafari religious use reasonable and justifiable in an open and democratic society?
The court had to act as a completely impartial referee here, balancing some really heavy competing interests. On one side, you have the severe, life-altering impact on Prince. His freedom of religion is denied, his dignity is attached by the stigma of criminalization, and he's literally barred from entering his chosen profession. But on the other side, the state has critical, undeniable goals: preventing drug abuse, suppressing illicit trafficking, and making sure South Africa fulfills its obligations under international conventions.
Ask yourself this question, because finding the less restrictive means is absolutely central to the proportionality test. Does stopping illegal street-level drug trafficking actually require the police to arrest a Rastafari priest for burning a tiny amount of cannabis as incense on a private altar? The court itself noted that there was zero medical evidence to suggest that burning cannabis as incense or using it in a bath poses any risk of harm or psychological dependence whatsoever.
So the court analyzed how an exemption could logically work in the real world without blowing up the war on drugs. The state tried to argue an exemption would just be too hard to police. But the court pushed back, pointing out that, hey, if we can heavily regulate highly dangerous medical drugs, we can certainly regulate this. You could establish a permit system. You could allow only registered priests, and there were only about 7 of them in the entire country at the time, to dispense it. Or you could limit the number of plants grown. The point is, less restrictive means were definitely available. The government just hadn't bothered to consider them.
Finally, Section 5, Judgment and Constitutional Remedy. Let's see exactly how Justice Ngobo and the Constitutional Court resolved this entire dispute. Justice Ngobo delivered a really profound thought in the ruling, stating, "The protection of diversity is the hallmark of a free and open society. It is the recognition of the inherent dignity of all human beings." It brilliantly highlights that in constitutional adjudication, true tolerance isn't just about allowing mainstream beliefs. It's about accommodating practices that might seem unusual to the majority, as long as they don't harm society.
So, the final ruling? The court agreed with Prince. They ruled that the statutes were indeed overbroad, casting way too wide a net over totally harmless religious practices. Because the ban covered uses that posed no risk of harm and could easily be subjected to strict administrative regulation, the limitations were disproportionate. They failed the Section 36 test. Therefore, the provisions were officially declared unconstitutional and invalid. And this is a critical point for understanding constitutional remedies. The court didn't just rewrite the law right then and there. They issued what's called a suspended declaration of invalidity, giving Parliament 12 months to fix it. Striking the law down completely overnight would have created chaos and unregulated drug use, which would undermine the state's legitimate goals. It is Parliament's job, not the judiciary's, to craft that intricate permit system. And unfortunately for Mr. Prince, because the law wasn't changing that very day, his request to immediately force the Law Society to register him couldn't be granted pending the new legislation. I'm going to leave you with this academic cliffhanger to really think about the fascinating boundaries between the judiciary and the legislature. The court clearly identified the constitutional breach, but then they stepped back, respecting the legislature's specific role to actually draft the new rules and regulations. It's a textbook example of judicial restraint woven perfectly into robust constitutional protection. Think about how that delicate balance maintains the integrity of our entire legal system. Thanks so much for joining me for this explainer, and keep questioning the law.